I have to bear my rent, accommodation, rent, maintenance, everything. I am a diabetic patient, and what is left with me? 15,000 per. What I am paying, I lordship.
You have been directed to pay 50,000.
50,000.
So if you are already paying 71,000, pay 21,000 less.
Fine.
It goes in your favor. Why are you challenging?
Electricity charges, which I am paying for the portion occupied by the opposite party, the ground floor portion. 2309 per month, which your lordship will find at page 97 to 100. EMI, that is equal monthly installment, I am paying for the home loan of joint property at Krishnapur, 17,431, your lordship will find at page 110 to 120. Total amount paid till date is 28,93,546 by the husband. Maintenance amount of joint property Krishnapur is lying vacant. What they have stated that it is given on credit. My lord, the deputy pass an order for appointing a special officer. Immediately go and inspect whether.
So suppose the court has held, trial court has held that you are earning jointly 18,000 rent from a jointly owned flat.
That's a wrong observation. This is a wrong observation, my lord.
Was it a part of either of your affidavits that 18,000 rent is coming?
Why we were staying together as husband and wife? Because it was a mutual agreement between me and the opposite party.
There is a jointly owned flat.
And I also offered.
There is a jointly owned flat. Who is residing there?
Nobody is residing. I'm the lock and key. This valuation, I have this query sheet at page 142,58,967, which even I offered. You can get that property. I can write it in your name and execute that deed in your name. You become the internal.
Suppose the court has found that wife's income is 58,501 per month. So apparently the wife is not entitled to any alimony on her account. Minor son has expenditure of 56,536. What do you have to say on that?
I am paying. I was paying before this.
No, whatever you are paying, you are not on that. As of today, why shouldn't this amount be directed to be paid? 56,000 is the expenditure of the son. That is the finding of the court.
That is the escalated amount, showing the birthday parties being celebrated.
Let us see from their affidavit of asset. That must have been the basis.
They have also handed over a sheet also before the trial court, like entertainment every Sunday.
Well, that is what in the affidavit of assets.
This is of 2022.
Well, let me consider.
Let us see the affidavit of asset.
At the time of hearing,
let us come to the expenses of the son. No. What are you doing?
They handed over at the time of
hearing. No. We look into only this. The affidavit of asset. Neither the trial court nor I can look into that. So they have already handed over their affidavit of asset. Let us find from that what is the expenditure of the son. What do you do, Mr. Bose, your client?
I'm a manager at Pricewaterhouse.
And him and her?
She's an administrator at JIS.
Let us see the son's income, son's expenditure. Sorry, from their affidavit, show me the son's expenditure.
Internal page 5. Internal page 5 of the affidavit of assets filed by the wife. Relevant information relating to the children.
Internal page 5.
Well, here it is the page 5.
This is 5.
My lord, regarding this,
you are the petitioner there.
Yes.
Affidavit of asset of the petitioner.
The relevant information, my lord, I have handed up two. One is of the wife, one is of the husband. So
this is the affidavit of assets and liabilities submitted by the petitioner. Petitioner was as in the husband. Anyway,
petitioner in the divorce case.
That in that way,
yes.
Very relevant information. This is the way. Let us see.
For the entire year, 58,000. I am paying these educational expenses for the child at page 127 to 130. You will find 6617 per month, more than that.
Let us first see from their affidavit. Let us come to internal page 5 of that. 10,000 per month is the creche.
Total expenditure they have shown us 56,503 per month.
Does it add up to that? If all these things are taken?
My lord, vacations twice in a 25,000 per month per vacation.
So you have to divide that by.
They could not produce.
You have to divide that by 12 months. So 2,000 per month.
That is how it has been done.
Every Sunday, park and movie theater 6,000 per month. Not supported by any document.
Let us start from the school fees.
Yes, ma'am.
School fees due amount is 35,000 per year. The last one, last year is 26,450. Total fees. Why is this discrepancy? Total fees and paid fees, Mr. Guho?
My lord, because this entire amount has been paid by the wife, he has not paid anything apart from 5,000 towards the child's expense.
So we have to take the total fees then.
Exactly.
61,550.
So, my lord, would here, if my lord kindly allow me to assist, my lord, at page 5, on 36, on the left hand side, how much expenditure has been incurred by the children during this period.
So current alimony will be only seeing the current alimony.
So, yes, means in order to say that how much it has been incurred, year-wise breakup has also been given.
Let us see the year-wise breakup.
Yes.
We'll come to 38.
Yes, 38. So
last year which you discussed there was 61,550 per year.
Yes.
Comes to around 5,000 per month.
Comes to around 5,000.
A little more than maybe 5,000 per month.
Yes.
5,000 for the school, 10,000 for Aya.
Now school books is for the year 1920, it costed around 3720. Similarly, my lord,
What is the school he is residing at?
My lord, St. James School.
St. James. St. James does not include within that.
No.
Only.
Then, my lord, would kindly see 8,000 per month is one maths teacher, one science group, and one teacher for other subject. He is of 12 years age. Monthly pocket allowance is 100 rupees per month given to the kid. School sports is 2,400 per year. Vacation twice in a year has been calculated to be 25,000 per vacation, my lord. Every Sunday, movie park, theatre, play zone. This is what my learned friend is highlighting so much. Is 6,000 per month that has been taken. School pool car is 2,500 per month. Medicine doctor's fee is 1,500 per month. School uniform, including PT class, is 4,000 per year. School shoe is 2,000 per year. Other school activities project 6,000.
Have you calculated, divided the part
yes,
year
my lord.
things
Actually,
by 12?
it has been done, and that is why by division 56,000 has come. However, my lord, kindly take a note of this fact that his fooding perhaps has not, because he is residing with me. His fooding and rest of the issues. And my lord, while maintaining a child who is residing,
you are also earning.
My lord, I am earning only 58,000.
58,000.
And kindly see my.
Why shouldn't the expenditure of the child be divided in the ratio of your income?
In the proportionate manner? That is
Ratio
what
of your
2021 says.
Yes.
In proportion. Now, my lord,
Yes.
kindly apart
He
from
earns
this,
double than you.
no. How much I have asked? I have asked before the court is only 65,000, against which I have been awarded with 50,000.
65,000 including your own expenses.
So 60, because out of which
it cannot be balanced. It has been held in Rajneesh itself. That it
exactly.
Cannot be
I'm coming, my lord. My lord, kindly see the figure what I have demanded at how much.
3,000 is sufficient to maintain
56,000 is son's expense. 10,000, 9,000 I have demanded for myself. That is what I have demanded. Court has not allowed. Kindly
yes, but for the son, let us consider about the court, about the son.
Yes. So
56,000 you say.
56,000.
He earns double than you.
3 times. He earns 3 times. His
what is his income? 1,50,000.
As on date, his in. That
is so 3 times. Yes.
3 times. And I earn 58. My lord, apart from this expenses of the educational part, my lord, there is a regular expense of fooding, lodging, and every day we have to take the son here, there, everywhere. My lord, those I have not calculated even.
Per month, 6,000 movie theatre and all may not be.
My lord, these days, my lord, birthday parties,
yes.
this, that. My lord,
birthday party doesn't happen every month.
My lord, there are travels, there are many other expenses. I understand.
Overall, what you cannot grant more than what you have claimed here.
Yes. So court has considered 56,500, and court has considered that in total I have not bifurcated. I have said if I get 65, I'll be neck to neck to maintain my son as well. And my husband, admittedly, in his affidavit of asset, he claimed that he has been only paying 5,000 rupees since 2019. That is his affidavit of assets. And he has not been bearing any of the fees. Be that as it may. Now, my lord, coming back to what is troubling, my lord, is Rajni's judgment of 2021. I have duly considered, my lord. There are 2 factors, 2 portions. If my lord allows me, I can place the judgment and show 2 portions of the judgment. What the
on what proposition? Tell us.
On the proposition is that if the wife is earning also, then also it cannot be said that he cannot be negated completely with maintenance.
The sentence before that and the sentence after that cannot be used as a tool.
No, that is, I'm not on that, my lord. Kindly, may I just hand up?
Suppose let him defend, then we'll come back to you. So in your reply, we'll take you.
Paragraph 90.2. though I'm carrying this judgment of 2014 as well, but I'll show it from, I'll not trouble my lord with 2014 because it has been cited over here.
Yes.
90.2, the wife had a postgraduate degree and
Yes.
was employed as a teacher in Jabbalpur. The husband raised a contention that since the wife had sufficient income, she would not require financial assistance from the husband. Supreme Court repealed this contention and held that merely because the wife was earning some income, it could not be a ground to reject her claim for maintenance. This is that maybe I am earning, I am not
You're
disputing.
calling out a portion of that. Let us come to the findings of Rajendra.
And my lord, then my lord kindly turns the page to an extent the maintenance of the minor child, paragraph 91 and 92.
Yes.
What are the factors? Because this judgment has been considered while passing this impugned order. The living expense of the child would include expenses for food, clothing, residence, medical expenses, education of the children, extra coaching classes or any other vocational training courses to complement the basic education must be factored in. While awarding the child support, it should be a reasonable amount to be awarded for extracurricular coaching classes and not an overly extravagant amount which may be claimed. Education, now kindly mark this portion, educational expenses of the children must be normally borne out by the father. If the wife is working and earning sufficiently, the expenses may be shared proportionately between.
That was said previously in other judgments also.
So my lord, and ultimately at the finding which my lord wanted to see at page Roman 6 at internal page 383 where the finding portion starts. And my lord may kindly come to paragraph 130, the criteria for determination of the quantum of maintenance. Hence, that has been given that what should be the criteria. This portion has duly been considered by the learned trial judge while passing this order. So in part B, Roman 3, the Honorable Supreme Court says that the criteria. So kindly come to page 371, which includes part B, Roman 3. Para 84, 372, my lord. This is the portion what has been held in Delhi High Court in Bharat case Saroj Here. They laid down the following factor to be considered for determining the maintenance: status of the party, reasonable wants of the claimant, independent income and property of the claimant, number of persons the non-applicant has to maintain, the amount should be aid the applicant to live in a similar lifestyle as he or she enjoyed in the matrimonial home, the non-applicant's liability, if any, provisions for food, clothing, shelter, education, medical attendance and treatment, payment capacity of the non-applicant. Some guesswork is not ruled out while estimating the income of the non-applicant when all the sources or correct sources are not disclosed. Non-applicant defray the litigation cost. The amount awarded under 125 is adjustable against the amount awarded under section 24. So this was the criteria. Now, my lord, apropos to this, my lord may kindly take a look at the impugned order and kindly see, because my learned friend's contention is that the learned trial court has not applied its mind while passing this order and there was no parameter. Now, my lord, if my lord kindly comes to the impugned order.
Yes.
Impugned order, my lord would see the first page, paragraph 6. My lord, may I? Yes.
Yes.
Paragraph 6, the court records the affidavit in by the respondent that his net income for the month of May 2024 is 1,62,000 and the gross income is 2,09,111. IT return for the assessment year disclose his total income is 15,56,680 and he paid an income tax such and such. The affidavit filed by him in 2022 discloses his income as 1,16,000. So while passing this order, the court considered that his income was 1,62,000. Now, my lord kindly turns the page and court records.
It says 1,16,000.
62. Because when he filed the affidavit of asset, that point of time it was 1,16,000. Subsequently, when the hearing took place and he was asked to produce his salary slip, that point of time he produced the IT assessment from where it
Where
has
is it
been
reflected in the order?
that income monthly May 2024 is
Salary slip for no.
Well,
your
that my learned friend has also relied in the civil revisional application. That is not disputed. That my lord will get at page number 88 of the civil revisional application that he draws 1,62,000. So, my lord, I'm trying to show that while passing this impugned order as impugned before my lord, what was going through the learned trial judge's mind in this thing. So he records 162. My lord turns the page
80,000.
He further records 18,000, and there are some, then he records that some discrepancies in the statement filed by the payer showing that the monthly expenditure of the minor's son and the salary slip filed by the respondent and the income on the relevant column. Now he relies on 2021 to Rajni's judgment, and he clearly lays down that what should be the criteria which I have just placed. After determining all these things, then he comes to paragraph 10, where he says, from the aforesaid discussion, it is found that the petitioner resides with the minor son at her marital home. Her salary slip for May shows that net income to be 58,000, which is 1/3, my lord. The minor son has expenditure of 56,000 per month for his all-round development. The income of the respondent for May 24 is 162. The joint income of the parties is 2,20,000 plus 18,000 rent from the joint owned flat. Then the total income earning comes to 2,30,000. In light of the said income of the parties, keeping in view of the liabilities and the head of expenditure mentioned on the affidavit, bearing in mind and the law in such and such, I do hold that an amount of 50,000 per month as maintenance and 25,000 as one-time litigation cost is fair and reasonable. Now, my lord, I ask for 65,000 consolidated, keeping in mind that my son's expenses, I myself is disclosing 56. Keeping in mind that my son's expense 56, wherein my income is 58,000. Keeping in mind that I have sought for 65,000, I have disclosed all the documents. My lord kindly considers the affidavit of assets that has been filed by the husband. I want to show one small thing, because since 2019, this dispute is going on, and what responsibility he has been taken. He himself admits, if my lord kindly takes the affidavit of assets filed by the husband, at page 6, the statement of expenditure, it starts. And then, my lord, at page 7, the maintenance of dependents, it is 48 serial. My lord has got that on the left hand side. Parents, he says nothing. Children, he says only 5,000. This is his admitted fact. He has not been taking care of the children, the child since 2019, and has been paying only 5,000 rupees, my lord. Wherein, apropos to this, my lord, the expenditure, the entire expense of the children is around 56,000, to which, my lord, court, after considering both the affidavit of assets and keeping in mind my income as well, has granted 50,000, my lord. Apart from that, there are insurance policies which does not find a place, my lord, which from time to time I have to maintain my son. I have to do it, and I have done it also. That does not form a part of it. That premium is I am also bearing, but I have done that very recently, so I am not bringing it, troubling my lord with that. But my lord, a son of 12 years age, he is growing up. This much is my income. What is my income is before my lord. Now, I am not even earning 1/3 of my husband. Apart from this, he has a rental income, and he says he resides in a rented flat. Perhaps, my lord, he resides in the flat that is of his uncle, and there is a pension that he is enjoying. We are not going into that dispute, because that is not a part of the record at the present moment.
He says he's not earning that 18,000 now.
He is not earning.
That
is his case. That is his case. But the court records that there is an separate income. But my lord, keep aside everything. It is an admitted fact, simpliciter, that I earn 1/3 of what my husband earned. I am maintaining a son whose expense is 56,000. And if we keep a reliance, place a reliance on the judgment nowhere says that since I am earning, I am not entitled for anything. It has to say that we have to keep that thing in mind, and for child's this thing, it has to be proportionate. So court has considered that thing and proportionately has granted. When court has granted me 50,000, that I have to, within that 50,000, obviously my son's entire expenditure will not be covered up. For over and above that, I have to regularly maintain him. His fooding is not included in it. These are such issues which we don't want to discuss.
Good.
But for a human being, my lord, it has to be.
Let us hear. Yes, Mr. Bose.
My learned friend's client has stated in her activity assets of library is internal page 5. Like hand over this particular sheet.
No sheet which is not on record.
These school fees which my learned friend is claiming, or rather the opposite party is claiming that she is paying, it's absolutely a wrong statement. It is me who is paying all the school fees. That too.
You have shown your expenses for the dependent son to be 5,000 per month in your affidavit.
No my lordship's attention.
In your affidavit of asset, Mr. Bose,
Might be. It might be.
then you are guilty of 340. Let me ask the magistrate to draw up a complaint against you.
Guilty of.
Your affidavit. Forget about others.
I know, my lord.
You cannot go beyond this. You have admitted in your affidavit of asset that you are
I have-
spending only 5,000 for your son. You cannot go beyond that. Sorry.
The school fees, I have annexed this document.
We cannot look into new documents now. Your affidavit of asset said you spend only 5,000. Forget your additional expenses. You have admitted that for your son you pay 5,000 only. Your wrong state. We'll record that and issue direct the trial court to issue a 340 against your client for suppression of material facts.
Ask them, get placed all documents with now nowhere in the impugned order it shows the reflection of any documents
No.
which we had placed before the learned trial court, as well as there is no reflection in the order that they had.
Your last salary slip says 1,62,000.
I'm not denying that thing.
So if you earn 1,62,000 and she earns about 58,000, around 60,000 suppose, added to that 18,000, there is nothing on record till the date of passing this order that you have denied that you pay 18,000. You get 18,000 for.
Right.
Have you disclosed that 18,000 in your assets, affidavit of assets? House rent income?
There,
Let us see. You say no. Let us see. Check up.
$15,000 is the rent expenditure
Where is that?
at internal page 6 of my affidavit of assets and liabilities.
Which item?
My affidavit assets and liabilities.
Monthly rent. Yes.
Monthly. Now it is around 27,000, which I have disclosed before this.
So this is your expenditure, which the court took as your income apparently.
Actually, because of the figure, it is getting confused. He himself in his said that he pays a rent of 18,000 as well. He pays a rent of
Where is the
18,000.
income shown? House rent income?
Well.
18,000? We don't find
Is
that.
the income sheet at page internal page.
What does the court get that he earns it?
At that point of time, it is 1,16,510.
No, that subsequently a producer salary slip. Where does the court get that he earns 18,000? Mr. Go, it is not there.
My lord, no, I'm also not saying that thing, my lord. What I'm saying is that court, there is
No,
an
page
income.
13, page 13.
Page 13. I'm also at page 13,
Page
my lord.
13, item
It
7.
says who is the owner of the residential accommodation. In case of rented accommodation, specify the monthly rent. So this he is showing perhaps that Atri Devnath monthly rent 17,000 per month till August
Who
2020.
is Atri Devnath?
17,000?
Who is Atri Devnath?
That my learner
Mr. Bose, who is Atri Devnath?
is his
You're not ready with your matter.
page, internal page.
You are Arindam Chaudhary.
You don't know this.
Your affidavit of asset, page 13.
Actually, she
43.
is my landlord. She is my landlord. Landlady, rather. At present, I am paying around 27,000. I have annexed the rent.
Right.
Receipt also.
Yes, Mr. Go. That was an error on the part of the court to hold that he earns 18,000. He pays 18,000. That is it, his affidavit of asset.
My lord,
Now I am paying 27,000.
my lord,
We
what
cannot
he's
look into
paying. My lord, my instruction is that he's staying with his uncle,
That's
and this is just a.
school fee, not.
My lord,
Mr. Go, there is no basis for this finding.
my
that
lord, I also understand. I'm not, and I'm completely not on that, my lord. On 18,000, I'm
So
completely.
we only asked you on 18. Take your seat.
Yes.
Yes, Mr. Bose, continue.
The school fee, not only 5,000. She has claimed in affidavit assets and liabilities that she is paying the entire burden of the thing. She is taking on the burden of paying the entire school. What my learned friend of submitted just a few minutes ago. The school fees for the month of first quarter 2019, 24,950 that was paid by check 20525725, and school fees second quarter 11,950, third quarter 10,950, fourth quarter, this is all, these are the amounts I am paying, not the opposite party.
Can't believe you. Your affidavit of asset says otherwise. Sorry.
Why?
Mr. Bose, once more you say that you have made a wrong statement in your affidavit of asset. We'll record that and I'll dispose of I'll keep the revision pending and I'll issue a 340 against your client. No difficulty apart from your client lying left and right. No. Whatever documents. You cannot go beyond your pleadings, and this is the purpose of Rajneesh versus Neha, that you have to disclose affidavits. No, Mr. Bose, we won't waste further time on this. We have to proceed on the premise that you have been paying 5,000 only.
I'm paying 25.
Don't make ridiculous arguments. Your affidavit, you're going against your own affidavit. That affidavit is an oath.
They have submitted also.
Mr. Bose, then you say that I'll record. You just say once more time that your client lied, and I'll record and I'll issue a 340. And why not right now? Esho. During arguments, learned counsel for the petitioner husband repeatedly reiterates, despite several queries of court, that his client, the petitioner husband, lied before the trial court while stating in his affidavit of assets that he is paying rupees 5,000 per month for his son. First up, it is submitted that the entire school fees of the son are being paid by the husband. First up, this court amply warned learned counsel for the petitioner that his client would be guilty of proceedings being drawn up for perjury if he insists that the said statement before the court below in the husband's affidavit of assets is erroneous. First up, despite the same learned counsel insisted on repeating and reiterating that the said statement is not correct, and his client, the petitioner, has been paying much higher amounts for this son. Next para, in view of such categorical admission on the part of learned counsel for the petitioner that the petitioner has made a deliberate and false statement in his affidavit of assets to the tune that he spends only rupees 5,000 per month for the son, this court is of the opinion that the learned trial judge should immediately consider drawing up appropriate proceedings for perjury due to the false statement of the petitioner husband before the trial court in his affidavit of asset. Next para, insofar as the impugned order is concerned, I find that the income of the wife has been held to be around rupees 58,501 per month, whereas the income of the husband, as per the current salary slip for May 2024, as produced in the court below, is rupees 1,62,047 per month. Next para, striking a balance between the two, we find that the husband earns about 3 times the wife. Next para, the expenditure for the son, as disclosed in the affidavit of asset of the wife in the court below, which could have been a valid premise of the learned trial judge in passing the impugned order, is to the tune of rupees 56,536.90 per month. Next para, although learned counsel for the opposite party wife submits that the food expenses of the son were not included in the said affidavit of assets, we find that taking a pragmatic approach, the amount of rupees 56,000 and odd would suffice to meet the expenses of the minor son, who is of about, what is the age?
12 years now. 12.
About 12 years of age. Next para, thus, the approximate proportion in which the expenditure for the son is required to be shared between the parties, keeping in view their respective incomes, would be in the ratio of 3:1. Next para, thus, the amount of maintenance directed to be paid to the tune of rupees 50,000, being barely above 3/4 of the expenditure of the son, I do not find any reason to interfere with the impugned order. Insofar as the litigation cost of rupees 25,000 is concerned, this court does not find any reason to interfere with the same, since the same is reasonable. Next para, as such, CO number 3746 of 2024 is dismissed on contest without any order as to cost.
My lord, my time. I take one indulgence. This is the letter I have issued several times. So
We cannot look into documents which are not there before the court.
disclose the width for the disclose the ideal path that I can pay directly to the school.
Call the next one, please.